Welcome back to Sunrise Live. My name is Sophia Wanuna. Earlier, we're talking to our digital editor, David Ohito. We're going through the newspaper review, talking about some of the stories that have been making headlines in the past week. And as we promised, he's now in studio, the chairman, CIC, Charles Nyachae. Good morning.
Good morning to you.
Karibu sana.
Asante.
Talking to us about the constitution implementation, how that process has been, how far it has come, and in terms of election preparedness, where does Kenya stand? I'll begin with asking, yesterday you launched your report. Congratulations,
Thank
I guess, are in order. 2 years on, and with the implementation of the constitution, you being a body charged with oversight, facilitating and monitoring that process. What are the challenges and what is the progress that has been made by the commission so far?
Okay, perhaps I could begin with the progress and the achievements.
Yes.
As your viewers will know, the Commission for the Implementation of the Constitution is a transitional mechanism that is established in the Constitution. Transitional in the sense that it's there for a limited specified period to do precisely what you just said, to monitor, to coordinate, to facilitate, and to oversee the process of the implementation of the Constitution, and in particular the legislation that is required to implement the Constitution, administrative procedures that are required to implement the Constitution, and generally to ensure that the Constitution of Kenya 2010 is fully and faithfully implemented in letter and in spirit.
Right.
Now, the best known, I think, part of our mandate is the legislative part of the mandate. That is the processing and review of the laws, the legislation that is required to implement the Constitution as set out in the 5th schedule to the Constitution.
Right.
Now, the 5th schedule has a number of legislation arising from the various chapters in the Constitution that have to be put in place within certain timelines. And to that extent, and really when we're talking about the achievements, that would be the starting point. That would be the first major achievement, that the process, and I say the process so that I'm not limiting the achievement to CIC, because there's a whole process. The executive originates the legislation. CIC reviews this legislation with particular reference to 3 issues. One, the constitutionality, to ensure that the laws that are being developed are in conformity with the letter and spirit of the Constitution. Secondly, to ensure that the laws are in consonance with other legislation that either exists or that is itself being developed under the Constitution of Kenya 2010. And thirdly, and very importantly, to ensure, because this is a principle in the Constitution, that legislation has received sufficient and effective public participation. Right. So that's what we look at, and in so doing, we under the requirements of the Constitution, we work specifically with the Attorney General, the Kenya Law Reform Commission, and of course with the line ministry in the executive that originates the particular legislation. Okay. And then when the legislation leaves us, it goes back through the Attorney General to Parliament, and ultimately under Article 261 of the Constitution, Parliament takes the responsibility to enact the legislation. So there's a whole process, if you like, and we have the constitutional responsibility to oversight that whole process. Now, in terms of the legislative part of our mandate, I would say that we have done pretty well as a country, because by and large, the laws have been passed within the timelines that are required. As I sit here, I think the one law which is still outstanding, and maybe if we shall talk on electoral preparedness later on, we will mention it, is the law relating to campaign financing. Other than that, the other laws are in place. Now, of course, you have a law like the Leadership and Integrity Act, which Parliament passed, and which was intended to be passed pursuant to Article 80 of the Constitution, that is in Chapter 6, and which had a timeline of August the 26th. The law was passed in the view of CIC. The law that was passed did not meet the threshold that is contemplated in Article 80 of the Constitution. And therefore, while we acknowledge that there was a law passed, we have sought judicial intervention for the Constitutional Court to say, does this law actually meet the threshold, and is it the law that is envisaged by Article 80?
All right, we will get to that. We will break it down and talk about each of these laws, especially those related to the electoral process. But what are some of the challenges, maybe perhaps before we get into the nitty-gritties?
If you'll allow me, just very briefly, let me mention two other areas of success very briefly, then I'll go to the challenges. The other area of success is the establishment of new constitutional organs and offices that are required by the Constitution. We're talking, for example, under this Constitution of Kenya 2010, the establishment of the Supreme Court. We are talking about the establishment and appointment of various constitutional commissions with specific mandates. We're talking about the establishment and appointment of independent officers such as the Director of Public Prosecutions, the Auditor General, the Controller of Budget, and so on. Those are in place. Again, a bit of a shortfall because, for example, an office like the Inspector General of Police ought to have been appointed much earlier than now. It hasn't, but we look forward, and now that we have a National Police Service Commission, and it has given its assurance that this is going to happen before the end of the year, really that is what is more important. Other than the fact that we are already late on that, so I would generally include those appointments as success. Right. But by far the most important success, we think, as far as implementing the Constitution is concerned, is the continued vigilance and support for the process by the people of Kenya. I think without that, the Constitution would be dead in water. I mean, but the fact that the people of Kenya continue to insist that this is their Constitution and they want the Constitution implemented fully and faithfully in letter and spirit, 2 years down the line, I see and feel that determination. From where I sit, that is an important continuing achievement. Right. Now, I'll turn to the challenges. There are a number of challenges, and let me say
the three main ones.
Okay, let me give you the three main ones. But let me say one thing, that when we're talking about a process like this, very often the challenges tend to get more emphasis than the achievements, which is okay, because then we challenge ourselves.
We don't relax.
Yeah, we don't relax. But it's important that, for example, when we identify a challenge that is associated with the executive or a challenge that is associated with Parliament, it's important that we are not suggesting or sending the message that the executive has totally failed or Parliament has totally failed or that they are not supportive of the Constitution. What we are saying is that, yes, they've done their part, but there are important gaps that have come about as a result of this. With that in mind, If I was to give you three principal challenges, I think I mentioned them when we launched the report yesterday. The first one is the whole challenge of getting right the respect for the governance structures and the rule of law as it is envisaged in the Constitution. So that, for example, when you have the executive fail to or delay in post-legislative implementation, as has happened with the example I gave of the Inspector General of Police, that tends to slow down and to adversely affect the process of implementation. More serious than that, perhaps because of what it reflects, is where you have a situation where there seems to be a clear and a deliberate failure to accord respect for the rule of law, so that where, for example, courts give orders and those orders are not obeyed. That fundamentally challenges the Constitution, because the role of the courts is to interpret the Constitution, it's to enforce the Constitution and its provisions. So when the court seeks to do this by playing its role of interpretation and handing down orders, and any other arm of government or state organ then declines or fails to obey those court orders, then this is a fundamental assault on the Constitution, and in an extreme situation could actually lead to anarchy. So that where, for example, the courts, I think one prominent example is where the courts declared the establishment of the county commissioners to be unconstitutional. But to my understanding, they still continue to hold office as county commissioners. You see, appealing the process, appealing is part of the process, but unless the decision of the court has been stayed, then at the moment at which the court pronounces itself, that is a law and it needs to be obeyed even as you appeal. Okay. So that does not augur well, and that is a major challenge for the process of implementing the Constitution. The other challenge that we have experienced is the failure to respect the process, the constitutionally laid process, in so far as the development of legislation is concerned. We need to remember why the framers of the Constitution, for example, established an organ such as the Commission for the Implementation of the Constitution, and gave it the mandate that it gave it. So that when you have laws that are developed that sidestep this institution, apart from that being a violation of the Constitution, there are other important negative consequences. For example, in all likelihood, you bypass the fundamental constitutional principle of public participation, which CIC has a responsibility to ensure. Of course, there are a number of instances where that bypassing results in provisions that are themselves unconstitutional, and they then have to be challenged, and this creates an uncertainty in the law.
Okay.
Because you asked me to give 3 examples of challenges.
Those are sufficient. Let's get to The critical time Kenya is heading to, the general election, it will be the biggest election in Kenya's history. An election like no other that will see the face of governance of Kenya completely change. And important is the electoral laws, those the laws that are related to the electoral process. And one of them is a gender rule, which really, as we stand, we're in a crisis of sorts. And if it continues as is, then the country will be in a very awkward position. If it stands unresolved and Parliament is set and the Senate seats, then an individual, a Kenyan, could go to court and say, you know, this is unconstitutional, and therefore they will not be able to sit. My question regarding that is, when the Constitution was being formulated, couldn't there have been a mechanism put in to avoid this kind of a situation, to avert this? Does it have to come to this that now last minute we're looking and seeking for a solution? Could not a mechanism have been included at the beginning of the constitutional making process?
Okay, let me say a couple of things. First of all, as it happens, the third challenge that I was going to mention relates to the electoral process and preparedness for the election. So it's good that that's what we are now discussing. If I begin by the issue of the laws that relate to the elections, the fifth schedule to the Constitution required certain laws to be put in place that relate to elections within the first 1 year. Okay. And this was done. So we're talking about the Elections Act, we're talking about the Political Parties Act, we're talking about the Act, the IEBC Act. Now, insofar as the laws that relate directly to elections are concerned, the one law which has not yet been enacted, although it did leave CIC some months back, is the campaign financing law. I can't really tell you why that hasn't been passed, because it did leave us, and it ought to have been found its way to Parliament and been passed by now. But it's somewhere between the Attorney General and Parliament. But we hope that when Parliament resumes in the next 3 weeks, that law will be passed, and that will complete the laws that directly deal with elections in terms of being prepared for the elections. And as I understand it, Parliament has also done its part insofar as passing or approving the election regulations. Yeah. Now, there are other laws which it was recognized need to be in place to facilitate a free and fair election. The timelines may have been a little longer, but these were fast-tracked. We're particularly talking about the laws relating to the police and the laws relating to judicial reforms. Okay. So the actual laws themselves were done. So insofar as laws are concerned that implement the Constitution in the electoral sector, other than the campaign financing, those are pretty much in place. Now, when we were reviewing or preparing the Elections Act, we needed to address the requirements in the Constitution, and in particular in Articles 27, 8 and 81B of the Constitution, which deal with the principle of not more than 2/3 gender. Now, 81B is very specific. It provides that no elective body shall have as its membership more than 2/3 of either gender. Yes. Translated into into non-legal English, what that means is that the elective bodies that you're talking about, the National Assembly and the Senate, if the day after the next general election either of those bodies has within the members that will be sitting there more than 2/3 of either gender. And I think taking our history and circumstances into account, I think it's
obvious the men will be
yes,
more
yes,
than the women.
Yeah. If we are in that situation,
Yes.
then as a country we will be in violation of Article 81B of the Constitution. And the point is that those bodies, yeah, whether you're talking about the National Assembly or the Senate, will therefore not be constituted in compliance with the Constitution of Kenya 2010. And therefore, from where I sit, will not be, those bodies will not be able to assume office, so to speak.
Could there not have been a mechanism put at the time the Constitution was being made in terms of now how this will be implemented? Fine, they've said 2/3, not more than 2/3 majority of any gender should hold an elective body, post in an elective public office. So wouldn't there have been a mechanism, and that's where now you're getting to ensure that this in itself is effected, if it's to force affirmative action, if it's to force this, instead of leaving it to parliamentarians, because so far there's been a stalemate. They've not been able to agree on what to do, and time is running out.
Yes. The question of time running out is probably true now, but this is not something that was noticed today or yesterday. I mean, this is something that this discussion has been going on for more than a year. To answer your question,
yes.
Possibly if there was a specific provision in the Constitution that had that mechanism, we possibly wouldn't be having this discussion.
This conversation, yes.
Because such a specific mechanism does exist insofar as the county assemblies are concerned. If you look at Article 177 of the Constitution, it does precisely that insofar as county assemblies are concerned.
Yes.
So that the political parties will provide lists to IEBC, so that once the elections have been done, where there's a shortfall, whichever gender there's a shortfall, the political parties will have what has been described as a zebra list, male, female, on the theoretical assumption that the gender could be, that it has a shortfall, could be either male or female, so that depending on the number of votes that each political party has received in that election, then from the party list, the IEBC will be able to draw names for nomination to the county assembly, so that that requirement will be met.
So why wasn't that done?
Now, I can't tell you why it wasn't done, but it wasn't.
Okay.
And I think there are a number of possibilities. Perhaps it was an oversight, I don't know, or perhaps those who framed the Constitution thought the process was self-evident insofar as how you achieve that. But I think for us what is more important is that in categorical terms, 81B requires that be achieved. Now, we looked at various options. Was it possible to achieve this with by statute within the Elections Act last year? And we collectively concluded, when I say collectively, I'm talking about the executive, I'm talking about CIC, I'm talking about the Kenya Law Reform Commission, I'm talking about IEBC itself, and I'm talking about ultimately the cabinet, which in recognition of that then authorized the development of an amendment to the Constitution, which was published in November of last year. So it's not like a problem that we have suddenly realized just before the elections.
Right.
The Constitution of Kenya Amendment Bill was published in November of last year. It had two things at that time. It had a proposal to amend the Constitution insofar as the election date is concerned at that time.
Yeah.
But the main thrust of the amendment bill was to provide a mechanism for ensuring Article 81B of the Constitution, insofar as the not more than two-thirds gender rule is concerned, is implemented. And if you look at the mechanism in the amendment bill, it's pretty much identical to the one that the Constitution provides for in Article 177.
All right. The Attorney General has sought the intervention of the Supreme Court on interpretation of this matter. What options are there, very quickly, before we take a short break, what options are left to ensure that after the elections, Kenya does not find itself in a constitutional crisis?
Quite frankly, I mean, it's a good thing to seek the
Supreme
Court's advisory opinion on any constitutional issue. But I think we need to remind ourselves that the issue really has not been, because the Attorney General's request for an advisory opinion is framed in terms of, is this requirement progressive, or does it need to be complied with by the time that we have the elections in March of 2013. Now, thus far, the debate was not that. Thus far, the debate was, and in our view, as CIC continues to be, how can we ensure that 81B, which is very specific in terms of its requirements, is complied with within the constitutional framework. So I want to believe that whatever opinion that the Constitutional Court will give will be an opinion that will help us in the sense that it will not be addressing the issue of is it progressive or is it not progressive, because in our view that is self-evident, but to pronounce itself on the fact that this is a constitutional requirement, and perhaps to say that in the absence of a properly constituted National Assembly and Senate in compliance with 81B, then we will have a problem. And
clarify, just in case it had been lost, because then when the commissioner was talking, he did not clarify that they were coming in a supporting position. It was as though they were coming in, the commissions were coming in to conduct the exercise in their own right.
Perhaps it's the way it was reported. I was at the press conference, and I think the CAJ's chair was in my view clear on that. So there's absolutely no conflict. I mean, the mandates of the respective commissions must be and will be respected by the other constitutional commissions. The intent was supportive, not
independent,
not to intrude on the mandate of any other commission.
Okay.
Yeah.
All right. Let's move on to the County Transitional Authority.
Yes.
And Kenyans, as we speak, we saw on July the 3rd this year, the commissioners, or rather the members of the authority, were sworn in. And as we stand, the public is unaware of the progress this commission has made so far.
Yes.
And time is running out, of course, as we said. We are getting closer and closer to the election. What systems have been readied to transition the new band of leadership into the new county government system?
Okay, like you said, the Transition Authority has been in place for a couple of months now, and they have come up with the initial plan of action. I mean, they have a tight time frame within which to ensure that the transition is such that on the 5th of March, when you have the new county governments, they are able to to hit the ground running. I think where, and I did say this yesterday in our during our launch, where perhaps there is some need in terms of communication, is because of this short time frame, is for the transition authority to keep the public informed, at every stage.
Has it informed the CIC? Because you were one of the commissions. It was to submit a report after 3 months. It's now after 3 months.
No, in terms of the report, it has done that. But don't forget the report is just it's a plan of action. Okay. But I think what the people need to know is the details.
Plan.
Yes.
Yeah.
That's their responsibility. We have under Section 15 of the 6th Schedule an oversight role again insofar as ensuring the system of devolved government is put in place. But the Transition Authority, as established by the Transition to Devolved Government Act, exists precisely to actually do that day-to-day preparation for.
Are you aware of any systems they've put in place, any mechanisms? Because what the members of Parliament recently criticized the authority for is dragging their feet, that there's a short period of time, Kenyans do not know what these people are doing. So we have a situation where governor aspirants and senator aspirants, women aspirants are out there campaigning, but after they are elected into office, where are they going to go? Where is the office? Where will they be set? And even just people understanding where is all this, how is all this going to fall into place? They seem to have failed so far.
I would be very reluctant to say that they have failed. What I would want to say, and I think we need to express, all of us, our legitimate concerns about these bodies. But I think we need to do so in a supportive way. I wouldn't say that I definitely would not say they have failed. Because we do know that they're working on this plan of action. But I think what is important for the Transition Authority is to be able to, on a very regular basis, tell the Kenyan people. And you see, the shorter the period, the more frequent the updates should be. So I don't share the view that they have failed.
But they have not done well so far, because would you be able to state any structures they have put up on the ground, any structures they've put up in terms of preparation for that transition, any?
Well, I wouldn't be able to, but I think that's precisely what I'm saying, Sophia, that I think where they need to be encouraged is to give this information. Remember, it's a mandate that we've given them. As a country, we must support them. We must call them to account, I agree.
Yes.
But I think to say that they have failed would be unfair to them. But I think the Transition Authority does need to come up with very clear and detailed briefing and very regular briefing to the people of Kenya, because there is that anxiety.
All right. One huge concern, and you did mention it yesterday as you were speaking, as you're giving your speech, is civic education. And, the preamble of the Constitution states, we the people of Kenya. So it's all about the people of Kenya also supporting in the implementation process, which was reiterated by all the speakers. But the huge challenge here is that most of the Kenyans do not understand the Constitution. Some have never seen it, some have not read it, majority have not read it. So even in terms of leadership, as you are out there championing and being very vocal and fighting to ensure that you have credible leaders full of integrity, people do not know some of the Kenyans do not know the mandate or the job description of a governor, of a senator. And so we have a situation where they'll be elected into office and Kenyans will not be able to hold them into account, because even in the first place, they don't understand what they're supposed to be doing. So in terms of civic education, Kenya is doing badly. And what needs to be done now? Yeah,
the two things here. One, I agree with you that we haven't done as well as we should have done in terms of the broad civic education. Now, I'm not in any way, apportioning blame. The broad civic education is...
who should roll it out? Who should conduct it?
The executive through the Ministry of Justice, National Cohesion and Constitutional Affairs. So and they have rolled it out. But again, perhaps this has come a little late and is moving a little slower than it should be. And I to the extent that they've rolled it out, and it's moving. It's unfortunate that it will not have been done to the extent that would have been ideal, but it's been rolled out. Now, the more immediate education that I think we perhaps could address our minds to is the voter education. Now, IBC, in my view, has started well with this, because they've rolled out the voter education, which will answer the sort of questions that you're posing, so that the voter knows how they're going to be able to discharge.
But they will vote, but who are they voting for? Because fine, it is easier to educate them. You're voting for governor, senator. But I think the bigger picture is, after you voted for them, then what? Because you'll be stuck with these individuals for the next, long period of time before we have the next election. So I think the biggest concern for Kenyans is an understanding of what are first our rights, and what are these people supposed to do once in office, so they can be able to hold them to account.
I absolutely agree with you that we are not where we should be in terms of in terms of civic education. But what I'm saying is that, and I did say the responsibility is with the executive through the Ministry of Justice, National Cohesion and Constitutional Affairs. But rather than condemn the ministry, I think we just need to encourage them to understand that there's a huge gap there, and that huge gap is detrimental to the process.
Right.
Yeah, because otherwise, this
we're doing a lot of encouraging. Notice we're encouraging authority now, we're encouraging the Justice Ministry, but these are key issues.
I absolutely agree.
So we cannot just sit back and say, yeah, please wake up.
No. And encouraging is not simply saying wake up. Okay. Encouraging is for everybody, every organ, to understand that the people of Kenya will hold them to account. What I am reluctant to do is to condemn and sit back. Okay. Because then
you're not helping.
That is not helping.
Yes.
I mean, we are not where we should be with civic education.
Right.
But so what next? What next is to insist that, that's what I'm calling encouraging. We insist that the executive has this responsibility. It has not been discharged to the level that it ought to have been. And for them to understand that people of Kenya will hold them accountable. As indeed, they will hold every organ that has any form of responsibility in this whole reform process accountable.
All right. A very critical question that is in the minds of majority of Kenyans. As the date has been set, 4th March 2013, in your opinion, is Kenya ready in terms of the laws put in place, in terms of civic education and all sorts of things? Is Kenya going to be ready for a 4th March election? You've said we are doing badly in terms of civic education. The County Transitional Authority is dragging its feet, clearly. It needs to wake up and do some more work. In terms of a safe election, because we have to have a free, fair and safe election, the National Police Service Council, is in position, is in place now, and they've rolled out the process of getting the top leadership of the service. But that is coming late in the day as well. Will the leadership, if the Inspector General then will be in office, have enough time to have a plan for the election to ensure we have a safe election as well? So that 4th March date, do you see it being possible? Fine, they might push for it, insist on it, but is it the best thing for Kenya? Given the current situation, as we've discussed, some of the issues raised, is it the best thing for Kenya? Is it the best suitable date to hold an election with our level of preparedness so far?
I would say this. I would say that it's important that we hold the election on that date, because failure to do so would throw the country into not just a constitutional spin, but a political and social spin as well. And that I want to suggest is for us as Kenya should be unthinkable. So what the challenge for us is, we have a 4th of March date, and we know what needs to be done as a country in terms of preparedness for that election. The laws are in place, the regulations are in place, other than the campaign financing law that I talked about. So what we are talking about now, we are talking about technical logistical preparedness by the electoral body IEBC. We're talking about the preparedness by the other necessary support services, such as the security services, for example. We are talking about you have mentioned about the level of civic education and the voter education, which IEBC has already undertaking. But you know what? We are also talking about every Kenyan and including political parties, including political leaders, every Kenyan ensuring that they behave in a responsible way insofar as the elections are concerned. Because at the end of the day, that is really what is going to ensure that we have, a credible election that everybody will walk away on the 4th of March saying yes.
All right, so you say it is important that Kenya has the election on that date, but on a scale of 1 to 10, realistically speaking, with all the outstanding issues, where does Kenya stand in terms of its real preparedness? Not imagined, not that in paper, real on-the-ground preparedness for the election on a scale of 1 to 10, in your opinion?
Sophie, to be honest with you, it would be responsible of me to attempt to answer that question for the very simple reason that there's so much technical information that even I don't have, the people of Kenya do not have. But I think it's a very important question that you should have the chair of IEBC sitting in this chair and tell the people of Kenya on a scale of 1 to 10, how prepared are we? Okay. It's an important question, but I think I'm the wrong person to answer it.
All right.
Yeah.
Okay. Let's go back to an issue that made news for a very long time, for a period of time, and it was about a hefty send-off package for the members of Parliament. And when President Mwai Kibaki declined to assent to it, the Finance Bill 2012, there was uproar in Parliament, there was debate, and they argued, actually your name came up in Parliament, and they talked about what your take-home package is. And what they were basically saying, you had initially come out to criticize their move, or were vocal, just like Kenyans were. We saw the middle class go out to the streets and say this is wrong. They shouldn't be awarding themselves 2 billion shillings as take-home package. It was seen as irresponsible and not caring for the people of Kenya. And but what now the question was, what right do you have then with you as a commissioner, your commission, and then Martha Karua saying when all commissions are put together, the amount of money raked in then cannot even perhaps come to comparison with what the members of Parliament are being accused of doing. What do you have to say about that in terms of whether you have a right to now be able to comment on their situation of seeking more money?
Okay, I think there are a couple of issues here, and I think it's important we identify what the issues are.
Yeah.
First of all, what we said as CIC, we said that the procedure that Parliament sought to use was plainly unconstitutional, was plainly illegal. That's not Charles Nyachae saying. That's in the Constitution of Kenya that establishes the Salaries and Remuneration Commission, a constitution which went through the same Parliament and was passed.
Yes.
The Salaries and Remuneration Commission Act was passed by Parliament. The powers of the Salaries and Remuneration Act, as set out in the Constitution, are very clear. It says the Salaries and Remuneration Commission will set the salaries for all state officers.
Right.
State officers are defined in Article 259 of the Constitution. State officers include members of Parliament, as indeed they include a number of other people from the President downwards. And to be very honest with you, it is not my responsibility or CIC's responsibility to say what any state officer, whether member of Parliament or otherwise, should earn. But it is my responsibility to insist that the constitutional process on how that is set must be respected. And the constitutional process is that can only be set by the Salaries and Remuneration Commission.
Okay.
I have never, CIC has never at any stage talked about the quantum of what members of parliament earn. If the Salaries and Remuneration Commission, Sophie, if the Salaries and Remuneration Commission had said that the members of parliament should take home that package, then it would be a different debate. I would not be raising a constitutional issue. The people of Kenya may have issues about quantum, and that is their right to do so, but it would not be CIC's position to argue about the quantum.
So in your view, the members of parliament were trying to divert attention from what the real issue is?
Yes. And let me make a comment, since you have raised about it. You see, here we're talking about the law, we're talking about the constitution, we're talking about processes. The Commission for the Implementation of the Constitution Act of 2010 has a mechanism. Remember, the commission was established before the Salaries and Remuneration Commission.
Yes. And
the commission has the Act has a mechanism for the establishment of salaries and remuneration for commissioners before the establishment of the Salaries and Remuneration Commission, which was basically that they would be set by the Public Service Commission in consultation with the Treasury. That's a process.
Yes.
That's exactly the process which was followed. Now, the issue of how much Charles Nyachae earns is a legitimate public issue, but it is not as limited as that. I think what is the real legitimate public issue is what is the public wage bill, how is it broken down, all the issues of how you get the balance right. That's exactly why we have the Salaries and Remuneration Commission, and that's why we are saying let them do their job.
Can it review salaries downwards?
Yes.
Okay.
Yes, that's their job. That's their job, and that's all we were saying. So to start talking about what any particular state officer earns, you know, whether you're talking about the president, a constitutional commissioner, or a judge, that cannot be an answer to the question of who is supposed to set the salaries and remuneration. That was diversionary. I honestly think it was unworthy of Parliament, that particular debate. That's my personal view.
All right.
Yeah.
Well answered. Let's move on to an issue that is also now in the judiciary, causing quite some ripples there, with the judges and magistrates, a vetting board. Yesterday, the High Court issuing a ruling that they have mandate to be able to give orders on the issue. 4 judges were granted reprieve, so they will continue to serve. They will not be sacked as yet. And the board was allowed to continue with its work. But the biggest concern is, shouldn't the final ruling lie with the vetting board? Because then if it's going to be reviewed by the same judges that are bound to undergo or have undergone the process of, you know, being vetted by the board, isn't there a conflict of interest, or rather protection, if I may say, of interests somewhat?
Yeah, Sophie, that question has vexed my mind since yesterday. And the only reason that I carried this copy of the Constitution of Kenya, because I anticipated that you will ask me that question.
Yes.
And I wanted just to take a minute for us to look at the specific provision that we are talking about. And it's a very sensitive and important issue.
Yes. Section
23 of the 6th schedule of the Constitution, that is the transition provisions, that's the one that deals with this whole process of vetting of judges. 23(1) sets the principle of the legislation that will provide that process.
Okay.
That's why we had the Vetting of Judges and Magistrates Act passed in April of 2011. Now, 23.2, and this is the one that should really concern all of us. 23.2 reads, a removal or a process leading to the removal of a judge from office by virtue of the operation of legislation contemplated under Section 1, subsection 1, the one I just referred to, shall not be subject to question in or review by any court. Here's the dilemma that we face. I think even in plain English, what I just read is fairly self-explanatory. Yes. I think the framers of the Constitution sought to protect that process from the normal judicial process, I think for a number of good reasons. One, it was important for the credibility of the judiciary that review process came to finality at the earliest opportunity. Secondly, of course, and I think you have mentioned it, is the issue of the interests that you're talking about the judiciary. It's the same judiciary that whose members are subject of the review. So I think the intention of the framers of the Constitution is clear. On the other hand, our constitutional architecture is such that any issue of interpretation of the Constitution is a preserve of the judiciary. Okay. So, in other words, even interpreting that 23 section 2, which I just read,
is up to the courts.
Is up to the courts. So, you can see the dilemma that we are in as a country, because we need to have that interpreted, right, in terms of the Constitution, but we also need to understand the context in which the framers of the Constitution included that. So I expect, if I read your mind, you're going to ask me what's the way forward on that.
Yes.
I think that in order to ensure that we achieve both, that we protect the judiciary and its reforms, and that we do not lose the intent of that provision in Section 23. I think that this is a matter which, at the earliest possible opportunity, should be definitively pronounced upon by the Supreme Court. Okay. So that we bring finality to the process. And I want to believe that the Supreme Court will find a way that retains that balance, that we don't lose the intent of the vetting process as provided for in Section 23, including the protection of that process from judicial interventions, which clearly is what 23.2 intends, but at the same time accord the Supreme Court as the final arbiter on the meaning of the Constitution of Kenya, any provision in the Constitution of Kenya, according to them their rightful role in the Constitution. Yeah,
because now Kenyans are looking at it as protection of interest, and judges fighting real hard to keep themselves, in office or protect each other's interests. We hope that will be resolved. I want to go back to a question I earlier asked you very quickly and rephrase it in terms of election preparedness. Yes, you did say that's a question to ask the IEBC chairperson, but regarding the Constitution, in terms of the laws and the ones that have been implemented, the election, the finance campaign bill is yet to be decided upon. So regarding that, the implementation of the Constitution, 1 to 10, is how Kenya is prepared for the election.
If you're talking on the issue of the legal preparedness, in terms of the legal framework for holding a free and fair election. In terms of preparedness, I would give it pretty close to 10. The only reason I wouldn't give it 10 is because we still have to have the campaign financing act put in place. Otherwise, the legal framework, the mechanisms such as the regulations are all in place. Okay, the regulations have yet to be gazetted, but they've gone through the process of development and approval by Parliament. So I want to suggest that that's not where, if there is a concern, that's not where it lies. That's not where it should lie. I think if there is a concern, and I think there are legitimate concerns, these relate to two things. One, the technical preparedness, and two, the technical in the sense of, we keep talking about sorry, we keep talking about, the what is required to do the registration and so on, technical in that sense. But on the other hand, the other area, if there is a concern, it's about the actual management of the process. Now, the management of the process includes managing political parties. It includes preparedness for vetting and determining who can and cannot run. It includes ensuring, which is a legal requirement, that political parties comply with their own constitution. It includes your constitution, and it is you, the people of Kenya, who has determined that this constitution must be implemented fully and faithfully. One of the ways that you have determined this will be done is the creation of a constitutional organ called the Commission for the Implementation of the Constitution. We, on our part, will continue to endeavor to be faithful to the mandate that the people of Kenya have given us. There are a number of other organs, many constitutional organs, which also have a constitutional mandate and responsibility. What is important for the people of Kenya is to continue to remain vigilant, so that they ensure that each one of these bodies, including CIC, is delivering on its mandate and for the best interests of the people of Kenya, and to hold each one of those bodies or offices accountable to them, to the people of Kenya. And finally, just to acknowledge thus far that one of the things, in fact, the most important thing that has kept this, from the perspective of CIC, that has kept the process of implementing the Constitution alive and robust is the support that the people of Kenya have given the process, including the fourth estate.
All right.
Thank you.
Thank you. Thank you very much. I appreciate you coming in this morning to talk to us. And our viewers, thank you very much for watching Sunrise Live this morning. We have been talking to Charles Nyachae, the CIC chairperson, of course, on matters constitution, the implementation process so far, the electoral preparedness in terms of the implementation of the constitution. And you've heard him say that at the end of the day, it's up to the people of Kenya to remain vigilant to ensure they are not shortchanged, but that the mandate by these bodies, including the CIC and other constitutional bodies, are met. They have been able to fulfill their mandate in line with the Constitution. It is our Constitution, the preamble. We, the people of Kenya, if you haven't read the Constitution, read it, understand it, learn it, live it. It is up to all of us. Thank you very much for watching. I'm Sophia Wanuna. Have a blessed Wednesday.